As the old saying goes, there are two certainties in life. Number one, death. And number two, taxes. We can't help you with death, but we've got you covered with taxes. This is Ask the Tax Attorney. As you know, the federal government doesn't play when it comes to owning taxes, but too many people freak out about it. So if you're a business owner and you're in trouble, or you're afraid you might be in trouble with the IRS, this is the show for you. Your host is a tax attorney with over 20 years of experience, and she's helped clients erase over $4 million in tax debt. So let's get to it. This is the Ask the Tax Attorney podcast. And now your host, Claudia Moncars.
Welcome to our listeners, and we want to give a special welcome to our guest today, Martin Saenz, and he is an employment lawyer here in South Florida. He represents both the employee and the employer side, so you can be whoever you think is in the dark side. He represents. I don't know. I'm a tax attorney, so sometimes I say when you're against the IRS, you are representing. I used to work for the IRS, and then you come back. You went to the dark side. That's what they say. So I don't know how they do it in employment law, but thank you so much for joining us. I really appreciate you joining and giving us some of your wisdom and knowledge here tonight.
Thank you for the invite. Thank you.
Yeah. And, I always like to tell people, yes, I'm an attorney, but foremost, I'm also a business owner. That's what I tell people. And, a lot of my clients, I tell them, I understand where you're going to, because I'm also a business owner. I have my firm. Gosh, I started when my daughter was born, and she's going to turn 14. So November will be our 14th year that we had the firm open. So I understand what it's been doing. We started from being small and having all those hats. So that's why one of my first questions that I like to always ask all the attorneys that come to our show is, can you please give us a small snippet of tell us about your business journey and how you end up becoming a business owner / attorney.
Thank you. Of course, everything begins with you working for somebody. Yeah. I work for somebody. And for those of you who don't know, lawyers tend to work many, many, many hours and do sometimes work that they don't love doing. I didn't like that. I started, I took the initiative and I left the firm that I was working with, took with me 5 clients. And within months, I was already servicing close to 700 clients.
Oh my God! I'm impressed.
And I never stopped enjoying it. I mean, the thing that I love more about a business owner, being an attorney, is that you can help the most people as long as you keep yourself organized. And you, of course, need to be the bestest lawyer to then teach your employees how to do it right.
I'm a tax attorney, so I love organizing. So the nerd in me is loving this.
Systems, all about systems.
Yes. Mm-hmm. And how long have you been in practice? You've been in practice for a while, right?
About 20 years. It'll be 20 years in May.
Okay, perfect. And have you, the 20 years of the firm has always been in employment law?
Every single year. I did more corporate and commercial litigation at the beginning in my first years. But after that, pretty much everything has been employment law, both representing employees and employers. And you don't get to be a good defense lawyer, in my opinion, unless you are really good at representing the other side. So it's a plus to know both sides of the argument.
No, and I think also it works for when you're a transactional lawyer, like when you do with draft documents. I have fortunately had, I don't do litigation, so I sat through some case. I did a pro bono litigation case, and that taught me a lot. So yeah, I agree with you. I mean, it's great that you have represent both sides.
Not only that, I think it helps employers because if you can approach your business by knowing what may come, then you avoid litigation that way.
Yeah. Perfect. So you've been in practice for a long time. Is there something, I'm sure you have a lot of stories that about great results that you've done for your clients, or just great how they thought a lot that just apply for business owners. Do you think you can give us a couple of them?
Absolutely. I think one of my biggest experience was when I decided to take on a case that didn't seem to be that big, and I took it on behalf of an employee, and later taught me a great lesson to help my defense clients, my employer clients. This lady was working for a big hotel, and she was making close to minimum wage, and we were litigating a case involving religious discrimination, and she was. I felt that she wasn't being taken very seriously during the litigation, and that taught me a big lesson, because that case ended up in trial, and my client at the time won a verdict of over $21 million.
Wow. Okay.
On a religious discrimination case. That taught me a lot, because since I've had that experience with employer clients or clients that are employers, I try to convey to them the idea that it's always best to understand what really needs to be addressed. In other words, what is the true behind the claim that was made by the employee. Because sometimes it's not that a person was discriminated for one reason or the other. It's more a matter of a confrontation or a fight, or something that the employee thought that wasn't fair, or that she wasn't treated fairly. And if the employer can learn to identify with an experienced lawyer what exactly that claim is, addressing it with a simple sorry, or with a minimal amount of money to settle the case, is probably the best approach at terminating the case effectively.
Oh, I love that advice. And that story, because I read an article one time that for personal medical malpractice, that doctors that tend to apologize for a mistake are less, the percentage was less of them being sued.
Oh, okay.
And I guess it is the same thing applies for employment law. If you just are willing to say, I'm sorry.
The big advice that I would give is the following: employees do not go talk to lawyers because they didn't get paid much, or because an employer didn't give them something that they promised. You get some of those claims, but most of the time, I would say 98% of the time, employees go to a lawyer because they feel that they're being treated different, or they're being treated in a manner where they're treated as second-class citizens, or because they were fired. Okay, so if an employer can address that right before it happens or while it's happening, and by that you need to have systems to control those instances, I think seriously that the employee never gets to go to see a lawyer, because the employee has nothing really to complain about.
And do you think, as business owners, is it a good idea to hire an attorney to help you with those systems, and just kind of have I know you have to have a handbook, an employment handbook, but just to give you the ideas or to guide you into how to set up those systems so you avoid the litigation?
Absolutely. And I think that there are two things that are very important. One, like you mentioned, to have all of those employment documents, like the manual, write-up forms, interview forms, termination forms. That's very important. But what is also as important is to train key employees in the business, such as management, so that they know how to use those forms, how to apply the rules, regulations, policies, and procedures in the company to avoid things falling through the cracks and then ending up in a lawsuit.
And is that something that if somebody, if one of our listeners needed some training of that, is that something that they can come to you for?
Absolutely. That's something we can do.
Perfect. So now I know your story had some tips on it, but do you still have I love giving tips to the more tips we can give, because sometimes, people think that lawyers are not approachable. They don't understand their things. So one of the big things of this podcast is to show them that we understand where they're coming from, because we're also business owners. So if you can just, a legal tip that applies to their business, that would be great.
I'll give two very short tips, and they both, if applied correctly, I think could save, I don't know, 50, 60, 70% of litigation. And those are as follows. Always record every single minute, hour worked by every employee.
What do you mean, like time? Like keep time?
Keep time especially on those who are considered not management.
Okay.
So keep a tab on every single hour work, regardless, because I've seen all kinds of employers, all kinds of employees, all kinds of litigation. It's always a good advice to have a blanket provision that you record. All of those are not management. You record every single hour worked by them. You record all of the pay. Not only because it's good advice, because it's law. All of the pay you give them, right? But also every single time an employee engages in an action that is a violation of your rules and procedure, document it, either writing them up or doing something similar. But keep a formal way to keep track of all of those write-ups, because the one thing that prevents or avoids lawsuits or makes them diminishes a lawsuit is the way that an employer kept records of what the employee did wrong. Because if the employee gets terminated, then you can go back and say he was terminated because he did A, B, C, and D wrong, as opposed to, he did A, B, C wrong and we never documented. And then the facts look more that it was because of something else, something that was illegal.
Yeah. No. I tell the same things to my clients for tax. Keep, and audit is easy if you have all your records. It'll be easy peasy. So I'm assuming the same thing for employment. Yeah, I'm a big fan of records. And when you talk about records, is it for keeping time? Is it just good enough to have it on a handbook, or do they do it digital, or does it matter?
I mean, you can do it. The law doesn't require you to do it in a specific way, but I would recommend that you either have something as cheap as a time clock, to something more modern where you require maybe a fingerprint or a code, an access code to clock in and clock out for lunch, and then time you leave. Because timesheets sometimes may be subject to an argument that they were manipulated. Whereas when you have electronic records or a time clock, that argument is more difficult to prove.
Got it. And then the records, when they violated the handbook, can it be as easy as sending them an email, or it has to be something more formal? That the more formal, the better. I assume lawyers like everything formal, but can it be as easy as an email?
If you get to a point where you as an employer will need to prove that the agreement was actually understood by the employee, and this happens a lot when you have arbitration agreements, for instance, or harassment policies in place. If you need to prove that they understood, you better have a way of showing that employee that perhaps was not a highly educated employee knew what he was reading and understood what he was reading. And you can do that by perhaps having a version in their native language, or by making it simple to access, and definitely require a signature or some sort of unique acknowledgement.
Great. Thank you. Thank you so much. I love them. I know I stress your tips a little bit more than, but I think because I know these are questions that I sometimes, my clients ask, and I'm like, I don't know, you have to talk to an employment lawyer. So thank you for giving us those tips, and thank you for giving us the time. And I think if somebody wants to get a hold of you, or, talk to you, and hopefully they're listening to us and they're going to contact you to set up their systems, because we're system lovers, both of us, and take preventive medicine, which is the best. How can they get a hold of you?
They can call me. That's the fastest. My phone number is 305-503-5131, or you can reach me via email. My email address is M as Mary, Saenz, like my last name, SAENZ, at saenzanderson.com.
And we'll make sure to have all this in the show notes too, so you guys don't have to. And I have a question. for employment law, does it work like tax law that you can take clients from all the U.S. or just the state of Florida?
I can only represent clients in the state of Florida. However, the law, federal law, it's pretty much the same in all circuits. And what I've done in the past, if I'm taking a case, let's say in Carolina or California or New York, then I have to get admitted pro hac vice in that specific court where I'm going to practice.
Okay. So for our non-Florida listeners, remember, Martin can help you out. And once more, I think I really love the idea of the systems and all that, and not just the litigation. So
Absolutely.
Once more, thank you very much for taking your time and giving us all this great advice as to our listeners.
Thank you for the opportunity.
Remember, if you enjoyed the podcast, please subscribe and share with anybody you think that will enjoy the advice. Thank you. Bye.
Thanks so much for tuning in to this episode of the Ask the Tax Attorney podcast. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. This helps others find the show, and we greatly appreciate it. And if they're in tax trouble, they will too. Once again, thanks for listening, and we'll catch you in the next episode.